Good morning, everyone. Good morning. If those who are outside can hear me and you're attendees for this session, could you please walk in? So first and foremost, happy World Intellectual Property Day. For those of you who are new to the country, welcome to Kenya. Karibuni sana. You came with the rain, so that's always a blessing. So we give it just, let's say 5 minutes, and then we can begin. But feel very welcome, get to know who's seated next to you, get to know each other. And yeah, we'll begin. For our online audience, happy World Intellectual Property Day, and welcome to our workshop today. My name is Florence Anyango Ogonjo from CIPIT, and I will be your host for the day.
Two, one, two.
Good morning once again. Good morning. It's lovely to see you all here today. So we will be beginning in a few seconds. Let me say seconds this time, because we are ready to begin. So once again, welcome to Strathmore University. Happy World Intellectual Property Day. Today we will be here commemorating World Intellectual Property Day through this workshop on promoting access to knowledge and the right to research. So this is a seminar that has been organized by the Center for Intellectual Property and Information Technology Law, CIPIT, and the Information Justice and Intellectual Property and IFOL in cooperation with the Kenya Copyright Board, also known as KICOBO for simpler terms. So welcome once again. And I'd also like to acknowledge our online audience who are listening from various learning institutions. So we have Jacqueline Dama from the Kenya National Bureau of Statistics. We have Justus Rotumoy from Kenya School of Law, as well as Charles Kisheru from Amangina University College. We have Evans Momanyi from Lukenya University. So to the rest of our online audience as well, welcome. So before we begin, I'd just like to first of all acknowledge once again all of you who are here. And with that, welcome Dr. Melissa Omino, the Acting Director of the Center of Intellectual Property and Information Technology Law at CIPIT. Also doing the introductory remarks will also be introduced by Dr. Melissa Omino, our Mrs. Faith Amatika Omondi, the Chief Legal Counsel at KICOBO, Dr. Dick Kawuya from the Right to Research Project, also for simpler terms, R2R. So as I welcome Dr. Melissa Omino, I'd just like to read her brief bio so that you're familiar with her. And before that, because we are all from East Africa, most of us anyway, and most of us are very, very local. And those of you who are international, you'll get acquainted with our East African anthem as well as our Kenyan anthem. So kindly rise up for the two anthems.
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
You may be seated. Our national anthems are great, right? They're nice. Okay, a couple of housekeeping rules before I call Dr. Melissa to do the welcome remarks. So kindly take note of the photography and videography notices to your left and to your right, so that none of you is unwittingly suing us in case you see your images somewhere. The notices are up there. In the event that you will need to use any facilities, they're right outside, to your left and to your right. Ladies to your right, gents to your left. Just walk outside and move to those directions. And in the event that you'll need any assistance for any purposes in the course of this day, you can touch base with myself and with Chabet, who should be waving her hand at you somewhere. Okay, if she's not, yeah, there she is. Yeah, with Chabet, just so in case you need anything in the course of the day. So again, let me introduce Dr. Melissa Omino. By the time I'm done with this specific one, you'll have known her name. So Dr. Melissa Omino is the Dr. Melissa Omino is the acting director at the Center of Intellectual Property and Information Technology Law, CIPIT. Dr. Melissa Omino is an intellectual property expert with a research focus on the development and negotiation of IP provisions in international trade agreements by and with Global South countries. She's a cum laude graduate with practical legal experience both in academia and practice. Dr. Omino also holds a doctorate in law focusing on intellectual property and trade law. Her range of expertise also includes legal frameworks within the sphere of artificial intelligence, data protection, and digital rights. She also focuses her energies in mentoring, nurturing researchers as part of her role as acting director at CIPIT. I can attest to that, where she leads projects in IP and data protection. Dr. Omino is also an advocate of the High Court of Kenya, must be mentioned. She's also a co-host at the Friendly Troll podcast, where she disseminates research to a wider audience in the Global South in accessible language. So, with a round of applause, kindly welcome Dr. Melissa Omino.
Good morning, everyone. I hope you can hear me. Hi. Oh yeah, that's much better. So, first of all, thank you for joining us in person on this rainy Nairobi morning. It's not easy to get a room with these numbers when it rains, but we actually enjoy it when it rains because it's a blessing. And because we have guests from within the country and outside the country, we are delighted that you brought the rain with you. So thank you for attending this World IP Day event on Strathmore University campus. This is, I think, the first IP event that we're having after the pandemic in person. So it's really a privilege and an honor to have you join us here today. I'd like to thank in particular our partners. That is the Electronic Information for Libraries, IFL, the Kenya Copyright Board. I hope you can still hear me. Otherwise known as KECOBO, as well as the Program on Information Justice and IP at the American University Washington College of Law. And of course, our distinguished speakers today and our guests both in person and online. Karibuni sana. Today's theme is Women and IP, accelerating innovation and creativity while promoting access to knowledge and the right to research. You can tell that I've combined the World IP Day theme and the theme that we are here for today, and I'll explain why I have done that. These two thematic areas are bound through the thread of women who are working to ensure innovation endures in the right environment. Our lineup today consists of the women on the front lines of access to knowledge and information, while also supporting the creative and innovation industries. These women include Dr. Grace Nyongesa, Dr. Catherine Nadain, Jane Grace Kinyanjui, Mrs. Faith Amatika Omondi, and Teresa Hackett, who are here today. I'd like us to give them a round of applause. And while it might seem obvious to some how research fosters innovation, it is also not a distant relative to creativity. Libraries play a pivotal role in fostering and nurturing the minds and passions of innovators and creatives. They are themselves on the precipice of innovation. Libraries are a custodian of knowledge and are charged with adapting to the digitization of various processes, now that we are moving from the analog to the digital world. Now, speaking as a researcher, creativity is also a part of my everyday work. Despite the fact that I am an accidental academic, and you can see me on the side for me to explain that, I am privileged to work with a team of women and men that support women, for whom innovation and creativity is a lifeline. I want to take this moment here today to acknowledge that team at CIPIT. So please give them a round of applause. And if you work at CIPIT, please rise up. Thank you. CIPIT has been conducting research in the thematic areas of IP and IT law for more than a decade. And as you can see, CIPIT is predominantly women. While 11 years is more than a decade, right? This is our 11th year. It is therefore a great honor for us to host this event and to speak around what the center does as an independent research center under the umbrella of Strathmore University. We are mandated to produce evidence-based work. Evidence may be viewed as an acronym to data. Just as we champion the awareness and protection of intellectual property, we are cognizant of the context in which this should be done. While we thrive for our work to have a direct impact on policymakers and government officials, such as regulators. Hi, Kekobo. We also offer support to various stakeholders in these thematic areas. The story that we will share here today will be a testament of that work, and the stakeholders who will be involved will be AI developers. As we move into our second decade, this work is something that we are consciously pursuing in terms of collaborative efforts. Collaboration is definitely a key objective in our agenda. This gathering here is evidence of that. The various stakeholders who have come together today truly make a formidable team. By the end of this day, we hope that you will remember the names of the women who are leading the charge in ensuring that innovation and creativity are not stifled, but bolstered by ensuring that the parameters of the protection of intellectual property are not pushed beyond what was envisioned by the theories of intellectual property themselves. We further hope that if you are a researcher, you will be a step closer to understanding what these parameters are and ensuring that you are well armed to utilize the exceptions available to you. Finally, we hope that the policymakers will take into consideration the various sentiments that will be shared here today while furthering and developing our laws. Asanteni sana. Now that was the difficult part of my job done. I can now move on to the interesting part, which is to invite other speakers here today to give us their perspective on the thematic areas. And the first speaker that I would like to come up is Mrs. Faith Amatika Omondi, who is the Chief Legal Counsel of the Kenya Copyright Board, KECOBO. Faith Amatika Omondi is the Chief Legal Counsel at the Kenya Copyright Board. She holds an LLM degree jointly from Ankara University and the World Intellectual Property Organization, WIPO Academy. Faith has had various professional engagements, including as serving as Kenya's focal point in the WIPO Committee on Development and Intellectual Property, CIDIP, and I hear there's a proposal at CIDIP to do with text data mining. Maybe we might hear about that. And it's Africa-based, yes? Okay. On the use of IP in the software sector, consulting for the US Civilian Research and Development Foundation, CRDF Global, and as a Cyber Policy Center Fellow right here at CIPIT, where she published a research paper on the regulation of deep fakes in Kenya. Have you read that paper? If you haven't, we can share copies of the journal. Faith has also contributed to the United Nations Global Digital Compact question of introducing accountability criteria for misleading and discriminating content through the E4E Africa's Digital Future Fellowship earlier this year. Wow, I'm out of breath. That's a lot. Please welcome Mrs. Faith Amatika Omondi to the podium.
Good morning. Good morning. Okay, I feel like I'm louder than you, so I was just wondering whether I was hearing you well. So thank you, Dr. Melissa Omino, for that wonderful introduction. As you've heard, I'm from the Kenya Copyright Board, and yes, we are the regulator of copyright in this country. So before I go further, I just wish to thank you all once again, just to reiterate what Dr. Omino has said. Thank you for making time to join us today on this cold morning, braving the rain and coming here to be with us in this workshop. We look forward to fruitful deliberations and an exciting time together as we discuss issues to do with research and making it possible for research, notwithstanding the copyright barriers that exist. I will see what to do about that and what the future holds, as we will see from my presentation later. So I'm here on behalf of the Kenya Copyright Board. Mr. Sigei, who is the executive director, was not able to come because he's engaged in another workshop. And also my colleague, Mrs. Sharon Wata, she's also not here because she's also conducting another workshop. You know, today is the Day of Women in IP, so she's also engaged somewhere else in another workshop on IP, the World IP Day, which is today. So among the functions of KECOBO is, you know, coming up with legislation and reviewing existing legislation to just ensure that it's in line with, you know, global trends and existing market situations. So at the moment we are working on overhauling the Copyright Act and issues to do with fair dealing, fair use, whatever you want to call it, exceptions and limitations. We are working on those at the moment, and we will be discussing that later. But I'm just here to represent KECOBO and to say that we are very much happy to be part of this, to be collaborating with CPIT and IFL as we discuss issues to do with, you know, making research possible and ensuring that this happens for the benefit of the creative sector and for everyone else that may be in need of the research activities or the research findings that are being developed or being churned out. So without much ado, I just wish to welcome you all to this workshop, and I know at the end of the day we will come out of here with something where we will say that we have learned something and that we know the direction we are taking as a country. We are not saying that this is the position, but we are going somewhere, and we hope that at the end of the day we will come up with, you know, a proposal or something that we are going to say this is the way Kenya wants to go. So thank you so much.
Thank you so much. Thank you so much, Faith, for that welcome address. We definitely are looking forward to your presentation later on today. My second task here today, it's not my last, but it's my second one, is to introduce to you Dick Kawoya, the Associate Professor at the School of Information Science at the University of South Carolina. Prof. Kawoya has deep knowledge and extensive experience in research, teaching, and advocacy work in the field of intellectual property and innovation, IP and the informal economy in Africa, and copyright and access to knowledge. And he has contributed to major IP projects in Africa and internationally. If you are part of the A2K world, there is no way you don't know about Professor Kawoya. At the World Intellectual Property Organization, he has participated in negotiations on copyright limitations and exceptions. So now you see why he's here today, including the Marrakesh Treaty for Persons with Print Disabilities and consultative meetings with the African Union Permanent Delegation in Geneva on copyright in the digital environment. Please help me by welcoming Professor Kawoya to the podium.
Good morning. How are you? All right. As Melissa has mentioned, my name is Dick Kawoya. I'm an associate professor in the School of Information Science, University of South Carolina in the USA. But the name and accent is from across the board, across the pond. Some of you will be familiar. I'm so excited to be here. This is home, sounds like home, feels like home, and everything tastes like home. I'm happy to see so many familiar faces, notably my good friend Charles Nandane, who I went to school with at Mackay University in Uganda many years ago, and quite a number of other folks who I know have joined us online. We are so excited to be part of this day, certainly part of this partnership with the CEPID as the Right to Research project. As Marisa has mentioned, or you've noted in the program, this workshop is in partnership with a project known as the Right to Research, which is hosted by the American University Washington College of Law in the United States. It's a basically global network of researchers, policy advocates, and civil society involved or interested in the subject of right to research. But the less technical term is what we call limitations and exceptions, or flexibilities in the international copyright law system. So we are talking about IP and women, and as you may be aware, there's enough empirical evidence which shows that women's contribution to innovation and creativity is often not acknowledged, certainly not in the area of IP. So when you look at the contribution of women, for instance, on patents, usually the numbers are so low. Yet women are very much involved in every sector, in every human enterprise. So it is only appropriate that today we highlight the work of women and their contribution, but also recognize that many times IP is an impediment to women or even people in general being able to make contribution to innovation and creativity. How so? So as you know, IP is primarily aimed at protecting rights of creators, whether authors or rights holders. But we also know that that innovation or creativity does not happen in a vacuum. So hence the need to balance, the need to protect, as well as making access to protected works. So when we talk about limitations and exceptions, we are basically talking about the need for flexibilities in copyright laws, certainly in the international copyright system. So that is important. Otherwise, there's not going to be innovation if people cannot access works that already exist and are protected by copyright laws. So today we are trying to weave those two conversations, issues of IP and women and their contribution, and the need for flexibility in the international copyright law system. And that is at the core of our work in the Right to Research project. This project, as I mentioned, is international. We have networks across the world, in Latin America, in Europe, North America, and of course, Asia, and of course, here in Africa. Here in Africa, we are part of a team led by IFIL, which is the Electronic Information for Libraries, and my colleague and long-term partner, Teresa Hackett, leads that team. I'm primarily responsible for the public advocacy work in the countries we work. So Kenya happens to be one of those countries that we selected to work. And of course, CEPID is one of our local partners and host today. So we are excited to hear about all the work CEPID has been doing under the Right to Research project. Today we are going to hear about some of the work presentation in terms of research. And also to learn about the important changes or activities that are going on with regards to copyright reform in Kenya, where we have opportunities once again to make the copyright law system more flexible and more amenable to the work that is done by women in this country and beyond. So without further ado, maybe I should not end before I mention, I introduce our team first and foremost. We have Madame Teresa Hackett, as I mentioned, from IFEL. You are going to hear more from her later in the day. But Teresa and I have worked for many, many years on issues of access to knowledge and copyright, focusing on libraries and culture institutions in Africa. So Teresa will be talking to us about our work and, of course, what we are doing in the Right to Research project. Next, Mr. Jonathan Band from Washington. Jonathan is an experienced legal scholar and public advocate for libraries and copyright-friendly, library-friendly copyright laws. So Jonathan will be talking to us later in the day as well. And finally, Sean Flynn from the American University Washington College of Law, who is also the PI of the Right to Research project. And maybe final note is to note that we are grateful to the Acadia Charitable Trust, which is funding this work. And of course, the many partners here in Kenya and around the world who are helping us to be able to make sure that we are making the most use of the resources under this project. So without further ado, again, thank you so much to CIPID. Thank you to Strathmore University for hosting us. And of course, thank you to Kenya for welcoming us in this country. And of course, we look forward to a productive day. Thank you.
Another round of applause, please, for Dr. Melissa, Madam Faith, and Dr. Dick. So once again, I will tell you welcome very many times. So we will be beginning today's workshop with the first session of the day. So the first session of the day will be moderated by Chebet Cross from the Center of Intellectual Property. The theme for this session is we'll be looking at perspectives from copyright users, teaching, learning, and researchers in the digital age. In this first session, we will be having Madam Grace Nyongesa from University's Academic Staff Union. We will be also having Jen Grace Kinyanjui, the chairperson of CLISC, and we will be having a short presentation, which I'm hoping will be the most interactive part of the day because it will be in video form, so it will be a bit more interactive. So allow me to welcome Chebet Koros as she welcomes the other panelists for this session. So Chebet Koros leads the research on intersection of intellectual property law and innovation at the Center for Intellectual Property and Information Technology Law in Kenya. Through her work, she aims to influence Kenyan IP policies as well as inform IP policy change within the region and globally. Her current research focuses on the role of Kenya's copyright law in enabling text and data mining research. She also researches in IP issues involved in artificial intelligence and has co-authored a handbook on copyright protection in Kenya for creatives and IP practitioners. So kindly allow me to welcome Chebet Koros.
Good morning, ladies and gentlemen, and I wish you a happy World IP Day once again. So as Florence has mentioned, I am a researcher at the Center for Intellectual Property and Information Technology, or CIPIT. You'll hear CIPIT a lot today. And I'm also an enthusiast of anything that makes you think, oh, that's new. In other words, I'm an IP lawyer and researcher. So today I am pleased to introduce to you our first session for the day, which sets the scene for this workshop or seminar. And the speakers for this session are unique to this year's theme for World IP Day. That is, we have 4 women who are working to accelerate innovation and creativity in Kenya. We will start our discussion with perspectives from copyright users. This includes teachers, librarians, and a researcher. And I'd like to first welcome Dr. Grace Nyongesa, our first speaker, who will offer us insights from a teacher's point of view. Dr. Grace Nyongesa is the national chairperson of Kenya's Universities Academic Staff Union, or UASU. She's a lecturer at the Kisii University School of Law, where she teaches gender and the law, among other subjects. She's also a senior partner at GC Nyongesa and Company Advocates, where she works on family law issues and children's rights. She has served as a vice chair of the Federation of Women Lawyers, and she has also dealt with labor rights of employees. And she has served as a member of ESCRnet Women Working Group. She has also served as a chairperson of the Board of Management for Butere Girls High School, and she is also a trained mediator. Please join me in giving a warm welcome to Dr. Grace Nyongesa.
A very good morning to all of you. Happy Intellectual Properties Day to all of us. It's very difficult to be the first speaker, isn't it? I don't know why the wisdom of the program creators thought that I should be. Apologies, I don't have PowerPoint for reasons I explained to Chebet. We have been overwhelmed with a lot of work at the union work. I was worried that the day may come and there's something very urgent that has to be handled. And when it comes to union matters, it takes priority. But I'm happy that I'm here today to share a little bit of what we as teachers at the university experience with regard to promoting access to knowledge and research, and so far as intellectual property is concerned. Thank you so much. Happy to see also my friends, Teresa, we met in Geneva, and other colleagues, some whose names I know, but I'll be able to see them physically. David, we also met in Geneva. What gives us our mandate under the Intellectual Property Act is the Constitution of Kenya, Article 33. And this we will interact with a lot from other facilitators, of course, from Kenya, which sets the rights and provided for research and copyright, and it guarantees the right to freedom of expression. This encompasses the freedom to seek, receive, or impart information or ideas, artistic creativity, academic freedom, and freedom of scientific research. The Copyright Act, as amended, also makes provisions for the exception to copyright by way of fair dealing for scientific research purposes, provided that the author is acknowledged. Despite the fact that this is permitted for reproduction, translation, or adaptation, distribution, publication, and broadcast of the work for the limited purposes, as provided for by Section 26, it fails to provide a definition of fair or scientific research, and therefore creates uncertainty on whether text and data mining research falls under this copyright exception. Copyright exceptions appear hardly adequate and effective to enable educators access knowledge and transfer or disseminate information. There appears to exist conflicts between the right to education arising from the fact that the educational materials in which the authors may have material interest that are critical to the realization of the right, and balancing the educational need for the educational materials that may be protected with the right of author to material interest remaining problematic. I will focus on the challenges in our system. Most of it now we are realizing, especially in the wake of COVID-19, the pandemic, most institutions were forced to teach online, and it became problematic for quite a number to adopt and teach online because there were, is that already spent? Remaining? Remaining? Okay, thank you. It becomes confusing whether it's the time remaining or time already spent. Especially with the pandemic, it was difficult for many to teach online because many lacked policy and framework to teach. And quite a number of lecturers were not, they were not flexible to post their material online, their teaching material, and accessibility to libraries became a challenge at the time. Students could not access books, and many universities, I speak from the university perspective, may have not had enough online material to enable the students' research and respond to the lectures that they were having. So that essentially saw lecturers then forced to post material online, and that is where most of the problem is. Now you'll find copying, the word copying, is an essential part of university education in Kenya. What remains uncertain is whether copying takes place in fair dealing or not. The difficulties that the law poses to educational copying, especially fair dealing factors, have an effect that is not good on copyright users of the copyright materials. The current legal rules on copyright also have a major implication for higher education in Kenya. The fear is that the rules may impede not only access to knowledge, but also transfer and dissemination of information. Oftentimes, disputes may arise where what is fair is left to the user to decide and the owner to disagree. And this raises a lot of uncertainty. I will then look at what are some of these challenges that then give rise to copying. Unaffordable access of material. That's one of the reasons that we have copying taking place. People are unable to afford to buy materials. You may find certain books are very expensive that the universities may not be able to afford to buy the kind of copies that are required even in the library. I'll look at, for example, the Council of Legal Education. They want a certain number of copies in the library as per the students. I think it is 5 copies, is it per 20 students or something? 5 copies per 20 students. And where we have one book costing about 50,000, that may be a tall order for the universities to afford because of underfunding in the university. And therefore, copying takes place. And then the second point is that current legal rules on copyright have a major implication on higher education. The failure of the Act to define fair dealing or give guidelines regarding the relevant factors in determining fair dealing also have a major inadequacy in reference to institutions. Both teachers and students use other copyright works in different ways for research, criticizing or reporting news, as long as they think that these rules are fair. So when there are no proper guidelines on what is fair, it poses a challenge. There is also restriction to access to materials. The restriction makes it difficult for the researchers to access information. Transcription is also a challenge to those using Braille. The other point is that special needs materials do not reach institutions on time, and both the basic education institutions and universities, you'll find that where there are special needs materials, these materials do not get to the institution on time, and this is a challenge. Lack of resources due to underfunding. Underfunding is one of the things we are dealing with at the university. And research funding is no longer coming in as it ought to. And this is also a challenge. Many universities also lack agreements with reproduction rights societies or copyright owners. And the other challenge we have is poor internet connectivity and infrastructure. Then why do people photocopy? The works that are photocopied include textbooks, journal articles, case studies, lecture notes, decisions, and statutes. I focus a bit on law because that is my area as a lawyer. Sometimes we want our students to have the statutes, they are unable to have them, so they photocopy the statutes, but it's always good to have the original copy. Why photocopy? Because the journals may be sold out or not available from the publisher. Libraries also have insufficient copies available. Borrowing rules are stringent in certain institutions. Maybe you're allowed to borrow for 7 days, 3 days, a week, 2 weeks. And this makes it a problem. That is why we have then, if you access the book, then you'd rather photocopy and use the pages that you want. Then the prohibitive costs of accessing materials. So the fair dealing issue needs to be looked at, because we find that without proper policy and guidelines on what actually includes fair dealing, as regards copyright limitations and exceptions for educational purposes, then there is ineffective, there seems to be hardly effective or adequate policy to enable users access knowledge as well as transfer and disseminate knowledge. I think I've been shown time, and I know other facilitators will be able to tackle other areas that I may have wanted to deal with. But as I was looking through, I came across a case at the Supreme Court, that Supreme Court of Kenya. Of course, judge-made laws also become laws for purposes of our use in our country when we are confronted with an issue that the legal framework has not properly placed within the statutes for use. When an issue comes, then we subject it to the court, and when the court makes a decision, it then forms what we may use. But it is important to have policy and laws properly elaborated to enable the users of materials, copyright materials, to use them fairly within the legal framework. I think I've exhausted my time. 2 minutes. So the case is the one of the Communications Commission of Kenya and 5 others versus Royal Media Services Limited and 5 others, which was decided by the Supreme Court. And the court interpreted Section 26 of the Copyright Act by applying 6-factor tests to determine fairness. The court assessed the purpose of the dealing. Second, the character of the dealing. Third, the amount of the dealing. Fourth, alternatives to the dealing. 5, the nature of work. And 6, the effect of the dealing on the work. And the court found that the use of copyrighted work in that particular case satisfied fair dealing defense to copyright infringement. So I want to end mine at that, and thank you for paying attention.
Thank you very much, Dr. Grace Nyongesa. Despite my attempt at increasing my height, I've been reminded my height is not as others. So thank you very much, Dr. Grace Nyongesa. That was a wonderful presentation. Thank you for providing us with valuable insights into how the work of teachers has changed in the digital age, and also sharing with us the challenges in the system, which include online teaching, accessibility to resources, and also the uncertainty of the law, which I think a couple of other presenters today will take us through that further. So I'd like to introduce our second speaker, and now we'd hear the perspective of a librarian and their new roles in the digital age. I'd like to welcome Jane Grace Kinyanjui, who has over 31 years of working experience in academic libraries. She is the university librarian at Egerton University. She is also the chairperson of the Kenya Libraries and Information Services Consortium, or CLISC, and the CLISC country coordinator on copyright matters. She has a Master's of Science degree in Information Science from Addis Ababa University in Ethiopia, and she's a transformational leader, having undergone the Transformational Leadership Program at the International Leadership University. She's an ardent negotiator after attending various training in licensing and negotiation organized by INASP. She's also an expert in the monitoring and evaluation of information resources. Please join me in giving Jane Grace Kinyanjui a warm welcome.
Good morning. I'm glad to be with you this morning to talk about the changing roles of librarians, not only in Kenya, but all over the world, due to the technological advancement that are taking place all over the world. I'm glad especially to participate in today's forum because I'm a woman. And fortunately or unfortunately, the case in Kenya for libraries is actually unique. We have more women librarians than male librarians. We need to do a research and find out why. We have more librarians in Kenya who are women as opposed to men librarians. So I stand here on behalf of CLISC. As I've been introduced, I'm the chairperson of the Kenya Libraries and Information Services Consortium. So I will start my presentation just to give a brief about CLISC and how CLISC came about. CLISC is actually a national consortium for libraries in Kenya, and it was actually established in 2003, and the main reason for its establishment was the financial challenges that librarians and libraries were facing in Kenya. And the financial challenges led to budget cuts for libraries, and therefore libraries were not able to access the peer-reviewed journals that they were initially able to subscribe to. So this made librarians come together, and especially at that time, they were mainly public university librarians who came together and put their heads together to find a solution to providing access to researchers who were still doing a lot of research activities, but the main challenge was the information that they required was not coming the way it used to come before because of budget cuts for libraries and, of course, for academic institutions and research institutions. So librarians came together in 2003 and established what we are now calling CLISC, which is the Kenya Libraries and Information Services Consortium. The main aim of CLISC was to bring together libraries and librarians to be able to leverage on the numbers. Please go to the next slide. To leverage on the numbers and pool resources, the financial resources. The next slide, please. Yes, so the CLISC was actually to bring together various libraries in Kenya, both academic, research libraries, and even government libraries, and pool resources, their financial resources, so that leveraging on the numbers, they can be able to negotiate with key publishers to provide access to the electronic information resources that our researchers, our students, our faculty required to carry on their research activities and academic activities. So that was the main reason for establishment of CLISC, and for sure, since its establishment, today we are actually celebrating 20 years of existence of CLISC, and throughout the 20 years, we have had a number of institutions joining CLISC. We now have over 140 members who are active members of CLISC, and these members are mainly from public and private universities, government agencies and ministries. We also have public libraries, national museums, and we have not-for-profit tertiary colleges and research institutions. And in the 20 years that CLISC has been in operation, they have had a lot of achievements. One of the key achievements was to create capacity. It has built a lot of capacity in our various libraries and in the public and private institutions. We also have libraries in the research institutions, and these librarians have been trained in various aspects that help them to become better librarians, to provide access, to help researchers get access to the electronic information resources that CLISC has provided. We, as CLISC, have been able to subscribe to various databases that our member institutions are able to access and actually be able to carry on with their research. So CLISC has played a key role in providing knowledge to various researchers in Kenya and academic staff. CLISC has also played a key role in advocating for open access resources. And recently, actually, we embarked on a project that was funded by one of our donors, and this project was actually able to assist the librarians in various institutions, spearhead establishment of online access journals using the open access software or open journal systems. So we acknowledge the fact that today there's a lot of ICT advancement, and as librarians we are asking ourselves, how are we going to still offer the services that our researchers need, our academic staff need, our students need with the technological advancement? We find that the information seeking behavior in our institutions has changed because of availability of ICT. We find that the students now, and even the researchers, and even the lecturers, as Dr. Nyongesa has said, they are now trying to access electronic information resources from wherever they are. Actually, they demand that I don't have to come to the library for me to access the information resources. So what are we as librarians supposed to do? We have tried to change our or rather modify or amend our library and information services to suit the information-seeking behavior of our researchers and our users in our various libraries. We find that due to advancement in ICT, there is a lot of digitization of information resources, and these information resources can be accessed through the internet. So we find that as libraries, we are now forced to move away from the physical desk that we were sitting and waiting for the users to come to the library. But now we have to go out of our libraries and ensure that we are interacting with the researchers to know what are their needs and how best do they want us to serve them. So we have actually even provided access to information resources outside the physical libraries and even the physical campuses. We have, through CLISC, been able to facilitate a lot of libraries to acquire off-campus access software, which allow them to provide actually that information outside their library buildings. We find that even though we are trying as much as possible to adopt to these new technologies that are coming to be able to serve our users better, it means that our roles as librarians are changing. Next slide, please. So what are the new roles of the librarians today? We find that as librarians today, our roles have changed. Initially, we were just custodians of the physical print knowledge in the libraries, and we had stacks and stacks of shelves. But we have to change from that. We have now to become educators. We are now trying to train our users. How best can you access this online information resource that is available? How can you access it? How can you assess its relevance in your area of research? And how can you utilize that particular information without infringing the rights of the creators, the copyright laws that we have been told about? We have to ensure that they are being adhered to. So we have gone out of our traditional roles as custodians of knowledge, custodians of print resources, to become educators. We have also become knowledge navigators. We assist a lot of researchers to be able to assess. We train them how to assess an electronic resource or an electronic article, to be able to see whether that particular article would serve the purpose of that particular researcher. We have actually also gone ahead to become research data managers because of the research advancement today. Research advancement today now requires that as a researcher, once you have done the research, you have to keep the data set. This research data set needs to be used by maybe another researcher in the next year or next year but one. So that means librarians have now come out of their role of being custodians of physical resources. They are actually now helping the researchers to manage these research data sets. And we have created, through CLISC again, a lot of institutional research repositories and databases in our various institutions, so that we can assist researchers to be able to even know whatever research has already been carried out, so that they can know what angle or what aspect to now explore after looking at what has already been done by previous researchers. So the institutional repositories have become key in our libraries, and as librarians, we have to know how to manage the research data and research publications and materials created by our researchers. We also have to have entrepreneurial skills. We have moved on now to become entrepreneurs. We are now treating libraries as businesses, and we are asking ourselves, what aspect can we innovate? What aspect can we be more creative to be able to serve our users well? In universities today, many users come to the library and ask, do you have a scanner? Can I scan this document? Can I print this document? I have worked on this research paper. What can you do to help me to be able to produce this paper? So we have to look at creative activities that we can do in the library to assist our researchers. However, we must say that even as we change our roles, there are so many challenges that we are facing. We have financial challenges that we are facing in the libraries and information centers. We are now having problems, for example, to control or to control the users from plagiarizing other people's work, because we have provided off-campus access to these e-resources. They are being used out there. So when the users are plagiarizing somebody's work out there, we are not able to control as previously when we were controlling within the library. So there are many challenges that we are facing, but we must ask ourselves, what can we do to combat those challenges? We know there's rampant copying, we know there's piracy, we know that the libraries currently do not even have enough infrastructure. For example, we do not have maybe well-equipped computer labs. So what is the way forward? The way forward actually is, first and foremost, we need to train the librarians so that they can be able to have skills that our researchers today need, so that they can assist our research as well. We need to have regular updating of copyright laws and reforms, and I'm glad the lady who was here before me said actually in Kenya, they are actually looking at the copyright law and seeing how they can change it. We need to learn to safeguard the intellectual property rights through accessing anti-plagiarism softwares, so that whatever the researchers come up with can be tested for plagiarism before it is presented anywhere, or before it can be passed for examination or can be published. We need to also enforce the citation and referencing styles and tools, so that when we use someone's output or creation, we should be able to cite that person, to acknowledge that whatever you are saying was actually created by someone else. So by acknowledging that person, you are actually creating publicity for that person. So I take this opportunity, due to time, I'll stop there. I want to take this opportunity to thank Eiffel for the support that they have given CLISC in various aspects. They have actually supported us to access electronic resources. They have supported Kenyan libraries to actually create more awareness even about these copyright issues, and even more awareness and adoption of open access. I take this opportunity to thank all of you for listening to me. May God bless you.
Thank you very much, Mrs. Jean Grace Kinyanjui, for that wonderful presentation and for sharing invaluable insights on the new roles and challenges that librarians face in the digital age, as well as also offering us practical recommendations on how to move forward. It's interesting to note that librarians are now research data managers as well as entrepreneurs and innovators. It's very interesting that everyone has to change their career based on the digital environment that we're living in. Now, I'd like us to continue in the theme of World Intellectual Property Day and switch it up a little bit. We're going to showcase the perspective of researchers in an exciting video presentation. Please give a warm welcome again to Dr. Melissa Omino, the Acting Director of CIPIT, to introduce the video.
They say when the applause starts to wane, people are now tired of seeing your face. And I'm very happy because this is my last role for the day. I promise you won't have to see me again. I am here in my capacity as a researcher, and to give you a little bit of an introduction to the video that will be played in a few. And I would like to tell you a story. And CIPIT is actually in the middle, or about to be in the middle, of learning about storytelling, which is precisely what has been happening here this morning. It's very exciting to carry out research, academic research at that, but I think in order to ensure that your research is reaching the right audience, then you have to tell a story about your research. Now, in this context, it wasn't difficult for us to be told, because it just happened. I am here representing the story of Masahane, and Masahane is in fact a grassroots organization whose mission is to strengthen and spur natural language processing. As a Kenyan, that was very hard to say, so you need to clap for me that I said that properly. So they carry out, see, I've messed it up already. Natural language processing research in African languages for Africans and by Africans. Now, NLP is part of artificial intelligence development, and that is AI. And they have a number of algorithms that they train. And while they were carrying out this research, they managed to develop a particular data set, a very popular data set within the artificial intelligence sphere known as JW300. And as I've mentioned before, they were doing this in order to enable access to African languages in the sphere of artificial intelligence. And this would help Africans further improve their research or improve the algorithms that are being used so they could cater for Africans and African problems. I'm not going to describe what JW300 is. I'm going to let Kathleen Simiu, who is in this video, explain that to us, what JW300 is. Now, you might know that CIPID carries out artificial intelligence, and you're probably thinking that that's where we came into contact with Masakhane. But actually, we came into contact with Masakhane in the area of intellectual property. While they were carrying all this out and collecting data, and I can pause here and say, there's a lot of mention of data here today. What do we really mean when we talk about data and data sets? Is it some amorphous thing that exists in the universe somewhere that somebody can go and collect by the handful? Or is it something that you sieve through different texts or different sound boxes or sand boxes, for that matter, in order to collate into something usable? You can answer that question later. But in their collecting this data set, they did not think about aspects of copyright. That came to them after they had collected the data set, they had tested the data set, and they were making strides within their community. So they approached CIPID to talk about intellectual property in general and to have a discussion about copyright in particular. And that's where the tables started to turn. I hope that I have enticed you enough to listen to the video, and I really would like to hear your thoughts after the video is played.
Welcome to the first ever Right to Research in Africa conference.
Kathleen, you're doing some exciting stuff.
My name is Kathleen Siminyu, and I am from Nairobi, Kenya. When it comes to doing sophisticated things with language tools, it's super simple to do them with English or another with major Western language.
So what then happens is that we as Africans who our first or preferred languages may not be the Western languages are then second-class citizens on the internet and on digital platforms.
So one of the things that you might want to do is just having metadata that just tells you, here's a new story, this new story is connected with this topic, right? We take it for granted that if you use other news aggregation tools, you can just choose these things and then they show up in, in English and German. But then we don't have that in our languages.
We can use AI to build language tools to bridge the gap. It would be great if automatic transcription or machine translation was available from Kiswahili to Luya or from African language X to African language Y. It would be great if educational material was easily translatable from English to another local language or medical information, and those are gaps that we can fill. We are enabling alternative futures. So within the Masakhane Research Foundation, we have a project known as Decolonize Science, and it's working to make accessible scientific material in various African languages. In the context of machine translation, the ideal data set is aligned text. And when I speak about aligned, this is at sentence level. If in Kiswahili I have the term Mimi ni msichana, I want an accompanying English text that says I am a girl. And then this data set is fed into a machine translation model, right? So the model is seeing very many different sentences that are aligned in the various languages, and this is how we get a translation model. The Bible is a great source of aligned text for obvious reasons. It's already set out in chapters, in verses, and then the work of evangelization means that many languages, especially African languages, are actually represented in translations of the Bible. The particular data set we used is one known as JW300, and it was created or curated from texts that are published by an organization known as Jehovah's Witness.
Their data set was a very rich resource in availability or inclusion of African languages.
We were able to connect to young people across the continent. It was easy for them to plug in because all they needed to do was select the language they wanted to train a model for. We published loads of papers. We managed to train very many machine translation models, and this work has been widely successful in Research Circle. Subsequently, beyond that comes the not so great stuff.
We started to realize that, hey, we should investigate the origins of this JW300 dataset.
We started to engage with legal partners.
Right now, we are going to hear to Dr. Melissa, who is going to tell us what rights do they have.
I am a lawyer by profession, and CIPIT is actually a legal research center. We were all agreeing that it was research work that they were doing. We sort of battled a little bit to understand what will the end product of the research be. Will there be commercial use? At the time, Jehovah's Witness, if you looked at the website, it said that it was copyrighted care of Pennsylvania, right? That's in the US. But there was also something else interesting on the website. They had a copyright notice. You could click on it and read what do they allow you to do and what don't they allow you to do. And they really laid it out that they do not allow text data mining. It was clear that we don't want you to do this. So that means we would have to rely on the exception. Whether or not it is legal for them to use text data depends on the jurisdiction. For example, in the United States, there is a fair use provision that would allow a developer or researcher to use text data for particular purposes. In Kenya, there is an exception, but it is a little bit more limited, and that's what we call fair dealing. And then there are other countries, such as Ghana, where there is no such exception that exists for the use of that data. This is Masahane, based in Africa. Do the grants allow them to test this in court or not? And the time, we didn't have enough time to even think about these things. So the best thing to do was to write to Jehovah's Witness and say, hey, this is what we're doing. And we've seen that you don't allow us to do that, but this is why we're doing it, and we believe that it would be fair use.
Jehovah's Witness declined. So the models still exist, they're still published, we still have the accolades we have received for the work that has been done, but then there's now a gap in the community because it's not as easy for very new researchers to plug into the work. It's sad that even with a plea and a demonstration of how much good has come of, the work that they have created, it's still a blatant no.
What happened with JW300? We became you become very concerned about the uncertainty that this places towards research within there, just because now you don't have a clear, especially even like a single market where you even know across the continent, not just South Africa, how do we handle kind of such situations?
The challenge with having exceptions in the law that have a narrow definition means that we are constantly looking for the interpretation of such narrow definitions. And it also does not allow future-proofing. And future-proofing is allowing for technology that we have not yet thought of to be incorporated within this exception. This means that policymakers have to really think broadly when coming up with these exceptions, or even change their mind about terming it as an exception and think about it as a positive right to actually research.
Wasn't that a fantastic video? Yeah. Round of applause to all the researchers who shared their insights on that video. And I hope you were able to spot a few familiar faces in the room, other than Melissa. So thank you very much. I'd like to mention that if you have any questions for our first two speakers, there will be a panel session, a Q&A session later on in the program, so just hold on to your questions. If you're on the online webinar, please use the Q&A provision, and we'll get to your questions later in the day. Now, I'd like to introduce our final speaker for this session, and I think there are very many, we have people from different areas with us in the room and online, and so we recognize that there are some terms that are been floating around which have not been defined, and we'd like everyone to be on the same page as we move on to the next session. So, having had the perspectives of the copyright users, our final speaker for this session will give us a simple, brief breakdown of what rights and exceptions from the copyright law provides. I would like to introduce my colleague Natasha Karanja, who is a lawyer and holds an LLM in International Commercial and Economic Law. She is a researcher at CIPIT, and her work focuses on intellectual property law, AI policy, and trade agreements with an overarching goal of applying decolonial theory within her research. Please welcome Natasha Karanja, who will give us a very simplified explanation on the copyright law in terms of research exceptions.
Morning to all of you. I hope you're having a great start to your day. Can I have the presentation on, please? So my job today is just to give you like a general understanding as to what copyright law is, the exceptions and limitations, and why they are important. So please, can I move on to the first slide? So copyright essentially is just like a legal right that's given to creators and owners of original work. So original work is held to be like a prerequisite for the legal right to be actually activated. So the legal right essentially provides for these bundle of exclusive rights that involve the use and distribution of the work for a prescribed time. The motivating factor behind this is more or less to compensate the creator for their intellectual effort. So the governing statute of this is the Copyright Act 2001. Can we move on to the next slide, please? So the type of works that are protected, we have literary works. Examples of these include, but not limited to, books, manuscripts, online journal articles, reports, poetry, and just basically lyrics of a song per se. We have musical works, we have dramatic works, we have artistic works, audiovisual, sound recordings, and broadcasts. Can we move on to the next slide, please? So these exclusive rights more or less are grouped into two categories. We have economic and moral rights. So starting off with economic rights, these are found within section 26 to 29 of the Copyright Act. So the underpinning notion is that it's a bundle of economic rights that allow all owners to enjoy all these economic benefits that are derived from their works. They include right to control, reproduction of the work, rights of distribution to the public by way of sale, rental, lease, or hire, rights of communication of the work to public and broadcasting of the work, right to export or import the work, translation into other languages, and adaptation of the work. So this is found within section 26 to 29 of the Copyright Act. So moral rights is found within section 32. These are rights more or less that are bestowed to the owner as a creator of the work. These rights include the right of paternity, so the right to claim authorship of the work, and the right of integrity, so the right of objection to distortion or modification of the work or any other action that is detrimental to the owner's reputation or honor. So it's important to note that these rights cannot be separated from the creator of the work during the author's lifetime. They can only be passed down to another person on the death of the creator. It's also important to note that the owner and creator are two different people. So this would be more or less in the case of like in the course of employment, where the owner of the work would be more or less the employer and the employee would be like the creator of the work itself. Can we move on to the next slide, please? So yes, so exceptions and limitations, what we're discussing today. So more or less, these exclusive rights I've mentioned earlier, they're not absolute, as is provisions that provide for exceptions and limitations. So basically, the purpose of this, more or less, is to strike like a balance of the interest of the authors, interest of users, and the public at large. So the underlying philosophy of the existence of exceptions and limitations to copyright law is mainly based on the belief that copyright is granted to authors by society in order for the latter to derive benefits from it. We can move on to the next slide, please. So more or less, the exceptions allow for use by third parties without the need of permission and also without the possibility of copyright infringement. We can move on to the next slide. So today, the specific exceptions and limitations discussed, we've mentioned fair dealing. This is more or less a general exception limitation. So there's fair dealing for the purposes of scientific research, private use, criticism of review, or the reporting of current events subject to acknowledgement of the source. We also have the inclusion in a collection of literary or musical works of not more than 1 page from the work in question for use in a school registered under the Education Act or any university. So where this is done, there is need for acknowledgement of the source that is required. So more or less, this exception is limited to educational institutions. We also have the reproduction of a work by or under the direction or control of government, or by such public libraries, non-commercial documentation centers, and scientific institutions for public use. So more or less, this is more applicable to public libraries. So next slide, please. Yes, so why are exceptions important? So the general benefit that copyright exceptions are important is that it improves information access to generate knowledge. And knowledge essentially affects economic, cultural, physical, mental, and social human development, as well as they enable information to be accessed to a wider audience through controlled reproduction. So therefore, both writers and publishers stand to benefit from exceptions in their official capacity as users of information and also as receivers. So from the educators' and librarians' perspectives, it would be extremely difficult for like an academic library to offer information services without some form of reproduction, like photocopying, especially given an environment where students and even lecturers rarely buy books, including myself. Exceptions increase the use of information services and supports research needs of users and enhances education. So this is particularly useful to libraries in developing countries, where countries are seeking to widen access to tertiary and higher education through e-learning. So in general, this like a summary of the presentation is more of a descriptive understanding as to what we're discussing today. So our presenters later on will provide more of an evaluative approach to the utility of the exceptions and the limitations. Thank you all for listening.
So that marks the end of the very first session for the day. Quick thing, because all the discussions were very serious and all of them were quite informative, just to say, I'd like to pick a few takeaways from what you've heard, just to make sure that you are all actually paying attention and in the room as the speakers were speaking. So just feel free to raise your hand. I could call people at random, that also works. We have the gentleman at the back. Pardon? What intellectual is. So any of the speakers, would any of you just let him repeat it into the mic, the question you've just asked?
My name is Nyanjom. I'm a university lecturer, and I think we often need to distinguish between intellectuals, academics, tutors, and so on. So we're talking about intellectual property rights, and there's an assumption that all universities, all lecturers, because they're in university, are intellectuals, and I think that distinction needs to be made. What is intellectual that amounts to intellectual property?
So basically defining what intellectual property is, separate from what the actual wording of intellectual is. Well, we'll see whether we have any takers who would like to give a more nuanced separation of definitions. And that, I think, will be taken up when we have the panel discussion in the afternoon. So anyone with any core key takeaways from whatever you've just heard? Again, like I said, I can always pick people. That always works. Okay, so what we'll do is I'll begin front, center, back. So I'll pick at random. So from the front, we have Miss Lillian Olivia, who's seated on my right, which should be your left. So.
Thank you so much, Florence. I'd like to thank the panelists for the great discussions. My key takeaway was the fact that in this digital age, the profession that you're in, particularly librarians, the fact that they were able to think of other innovative ways and creative ways of handling their users by being entrepreneurs was my key takeaway. Thank you.
Thank you so much for that, Lillian. We go to center, the gentleman in an orange sweater. I think your name is Robert, yes? Yeah.
So morning everyone, my name is Robert. I think my takeaway from this session was what was presented by Jane, so the aspect of what she called the Kenya Information, so I took it down. So the Kenya Libraries Information Services Consortium, so I didn't know about that, so that was my takeaway. Thank you.
Thank you so much, Robert. Then we go to the back. Let's see if backbenchers are actually alive. So we have the lady who's smiling at me with a red, white, and gray scarf. Yes, you.
Hi, my name is Elizabeth Oyange from Aga Khan University. So my takeaway is actually about the text and data mining issue with JW300. It's pretty surprising to me, but I always find that sometimes it's also in the way you ask, and I'd be curious to know how those permissions are asked. Thank you.
Thank you so much for your very much solicited comments. Also, something interesting that I also learned about the JW one, and we'll do a quick hand raise just to, for those of you who are religiously inclined and are Christian, how many of you have read the Bible in your mother tongue? In your mother tongue? Okay, there's a good number of you. So that's a good sign. That's a good sign. Okay. So with that, we will be heading off to our tea break. For those of you who had their morning coffee here, it will be at Watamu Cafe, just at the entrance of the building. For those of you who do not know where that is, walk straight ahead to your left. You will see Watamu Cafe there. So our tea break will be approximately for, give or take, 15 minutes, 15 to 30 minutes, but let's go with 15 minutes. Give yourself times to interact with each other, network, etc., etc., and then we'll be back for the second session of the day. Thank you so much. Slight reminder as you're walking out, for those of you who would want to take your photos, you can have them taken right at the entrance at the atrium. There is a photographer on call for you guys.
I'm good, yeah, I'm feeling alright. Baby, I'ma have the best fucking night of my life. And whatever it takes me, I'm down for the ride. Baby, don't you know I'm good? Yeah, I'm feeling alright. You know I'm down for whatever tonight.
Recording stopped.
I don't need the finer things in life. No matter where I go, it's a good time. Yeah. And I don't need to sit in VIP. Middle of the floor, that's where I be. Don't got a lot, but that's enough for me. Yeah, I'm good, yeah, I'm feeling alright. Baby, I'ma have the best fucking night of my life. And whatever it takes me, I'm down for the ride. Baby, don't you know I'm good? Yeah, I'm feeling alright. You know I'm down for whatever tonight. I don't need the finer things in life. No matter where I go, it's a good time. Yeah, and I don't need to sit in VIP. Middle of the floor, that's where I be. Don't got a lot, but that's enough for me. Yeah, I'm good, yeah, I'm feeling alright. Baby, I'ma have the best fucking night of my life. And whatever it takes me, I'm down for the ride. Baby, don't you know I'm good? Yeah, I'm feeling alright. I'm good, good. I'm good. Don't you know I'm good? Yeah, I'm feeling alright. So I just let it go, let it go. Oh, na 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 na, no, I don't care no more, care no more. Oh, na 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 na, so come on, let me know, let me know. Put your hands on na na na. Baby, nothing's gonna stop us tonight. 'Cause I'm good, yeah, I'm feeling